It has not been widely reported, but it is the case that California Attorney John C. Eastman has been under investigation by the State Bar of California since September of 2021 for ethics violations related to his attempt to have Vice President Pence participate in a scheme to overthrow the results of the 2020 presidential election. The State Bar of California's Chief Trial Counsel, George Cardona, announced on March 1, 2022, that since September 2021, his office has been investigating John Charles Eastman, State Bar number 193726, a California licensed attorney. According to Cardona, the investigation is focused on whether Eastman engaged in conduct in violation of California law and ethics rules governing attorneys following and in relation to the November 2020 presidential election. A number of individuals and entities have brought to the State Bar's attention press reports, court filings, and other public documents detailing Mr. Eastman's conduct, said Cardona. We want to thank those who took the time to bring our attention to this information, which serves as the starting point for our investigation. We will be proceeding with a single State Bar investigation in which we will continue to gather and analyze relevant evidence and go wherever it leads us. A State Bar investigation seeks to determine whether there is a basis for filing a notice of disciplinary charges. An attorney has a right to a fair hearing and must be presumed to be innocent of any misconduct warranting discipline until all charges have been proven in a proceeding before the State Bar Court. California is the only state with an independent professional court dedicated to ruling on attorney discipline cases. The State Bar Court hears charges filed by the State Bar's Office of Chief Legal Counsel against attorneys whose actions allegedly involve misconduct. The State Bar Court has the authority to recommend that the California Supreme Court suspend or disbar attorneys found to have committed acts of professional misconduct or to have been convicted of serious crimes. The allegations to the California State Bar focus on the fact that Eastman presented a two-page memo outlining a two-pronged scheme to have Vice President Pence overturn the Electoral College vote, which confirmed the election of Joseph Biden as the 46th President of the United States. We know that Pence refused to go along with Eastman's scheme, and that even in the face of the attack on the Capitol, which occurred on January 6, 2021, Pence fulfilled his obligations under the Electoral Count Act of 1887. He carried out the count of the Electoral College votes submitted by the state legislatures and declared Biden elected, as we see in the following video.
The whole number of electors appointed to vote for President of the United States is 538. Within that whole number, a majority is 270. The votes for President of the United States are as follows. Joseph R. Biden, Jr. of the state of Delaware has received 306 votes. Donald J. Trump of the state of Florida has received 232 votes. The whole number of electors appointed to vote for Vice President of the United States is 538. Within that whole number, a majority is 270. The votes for Vice President of the United States are as follows. Kamala D. Harris of the state of California has received 306 votes. Michael R. Pence of the state of Indiana has received 232 votes. The announcement of the state of the vote by the President of the Senate shall be deemed a sufficient declaration of the persons elected President and Vice President of the United States, each for the term beginning on the 20th day of January, 2021, and shall be entered together with the list of the votes on the journals of the Senate and the House of Representatives.
The House Select January 6th Committee recently presented conclusive evidence that Trump attorney John Eastman knew his plan to try to block the election would fail if it went to the Supreme Court. Yet Eastman continued to fuel Trump's hope. Greg Jacob, Mike Pence's chief counsel, testified to the committee that, "When I pressed him on the point, I said, 'John, if the vice president did what you were asking him to do, we would lose 9-0 at the Supreme Court.'" Jacob said Eastman first tried to say the Supreme Court would land at 7-2 in their vote if it came to them. Then Eastman admitted his legal theory would lose 9-0. Jacob's testimony became a cornerstone of the House's argument that Eastman and Trump likely engaged in planning a crime, a contention that federal judge David O. Carter agreed with when he commented in a proceeding to force Eastman to turn over many of his emails to Trump and other GOP officials prior to January 6, 2021, to the committee. Judge Carter said in his opinion that Eastman's actions amounted to a coup in search of a legal justification. But beyond this testimony, there is direct evidence from Eastman himself that he understood that his attempt to have Vice President Pence overturn the result of the election was clearly unethical, if not downright illegal. Prior to January 6th, Eastman had requested to have his name put on a list of people requesting preemptive pardons from Trump for possible illegal actions concerning the election. In addition, Eastman, when testifying before the January 6th committee, invoked the Fifth Amendment protection against self-incrimination more than 100 times in response to questions from the committee. The actions of attorney John C. Eastman to overthrow the results of the 2020 presidential election were highly unethical and very likely illegal. Please call the California State Bar to let them know it's time for them to act. The telephone number is 800-843-9053. Thanks for watching. If you haven't done so already, I would appreciate it greatly if you would subscribe to my YouTube channel, and please watch some of my other videos.